if you'll permit me, Chair. At 1.3 of that minute, it states that these are minutes, is the adoption of two sets of minutes. The first is a meeting of the 25th to the 28th of July 2012, and the next set of minutes is of the 15th of August 2012. Now, at paragraph 1.3, item 1.3 of that minute, it's a fairly long item, but then the specific issues are not numbered specifically, but overleaf, there is an entry that, the following entry: Lieutenant General, brackets, doctor stroke advocate, close brackets, Libeya suggested that page 20 of the NMF minutes be detached from the minutes as they did not form part of the NMF meeting. National Commissioner inquired if the minutes should be adopted up to page 19, and those who were part of the session will adopt. The forum members agreed. NETCOM concluded that the minutes should be adopted up to page 19. The extraordinary session will adopt up to page 20. The upshot of that is the minutes were presented to the NMF as a 20-page document. On the last page thereof, it dealt with the extraordinary session, and the NMF did not adopt what is reflected therein because it was not a matter that was before them, and they asked that it be excised from the minutes, and the National Commissioner then explained, to the extent necessary, the extraordinary session will then adopt that part of the minute. We make reference to this, Chair, as part of the next point we want to address, which are the terms of reference themselves. And these minutes go to the question of whether the NMF took the decision as described in the term of reference. We deal with this aspect.
So that's now dealing with the first
term of reference. And if I could just find my place. We start with that term of reference from page 13 of our heads of argument.
Okay.
And specifically from paragraph 26. The term, and I must read it out for purposes of what I will argue immediately thereafter. Whether the National Commissioner, acting together with other leadership of the South African Police Service or alone, misled the Commission by concealing that it had made the decision to implement a tactical option taken at the National Management Forum meeting on or about 15 August 2012. In our statement of response, members of the board, thank you, Chair. In our statement of response, we have indicated that on a proper reading of that term, this inquiry must make findings on three independent elements. It's got three elements in it. The first is that this inquiry must find that a decision as described in the term was taken by the NMF at its meeting on the 15th of August 2012. If the board confirms that such a decision was taken, then this board must inquire as to whether or not that particular fact was concealed from the Farlam Commission. And in the event that the board concludes that, yes, the decision was taken and that decision was concealed, only then does the question of whether or not the National Commissioner, together with acting with the leadership of SABC alone, misled the Farnham Commission. In our heads, we seek to persuade you, members of the board.
Paragraph?
We deal with this item, term 1, from page 13.
1.3.
1.3, that's of our heads.
1.3. Yes.
And we say, because of the way the term is structured, it potentially lends itself to a number of different interpretations. We have thus far managed to extract at least 3 possible interpretations. The first is whether the decision related to a tactical option being taken, which could be any tactical option, or whether it relates to their tactical option, which then would mean a specific tactical option. And those would be our 1 and 2 interpretations that we say probably attach to this term. The third is slightly more convoluted and we think most improbable. And that would lead to a view that the National Commissioner misled the Commission by concealing that the SABC leadership had made the decision to implement a tactical option. So now that excludes the NMF. And that such tactical option was then taken at the NMF meeting, but not necessarily by the NMF. And we say that is rather too stretched an interpretation. Any confusion as to what exactly interpretation should attach to the term is whether the decision relates to a tactical option or the tactical option. And we argue in succeeding pages that on the evidence adduced, both before Marikana Commission and yourselves, the following is a conclusion that we must draw. The NMF, as a matter of fact, did not take a decision to implement a tactical option. Such a discussion, we know from the evidence, was not had by the NMF. That is confirmed by the annex I recently referred the board to, which is LL2, which is once again the very body, the NMF, at its subsequent meeting of October 2012, confirming that it never had such a discussion and that those issues pertaining thereto should not be reflected in its minutes. Let's look at the other option, whether the NMF took the decision to implement their tactical option. And on the same basis, that is not supportable. So, and from paragraph 44, we seek to draw a distinction between a tactical option and their tactical option because it is important. And in this regard, we refer to the public order police at paragraph 34, use of force during crowd management, 3/1/5/1/174, dated 20th of July. And I think a year is missing there, 2012. I'll check the year check. But that policy appears as Exhibit S before the Farnham Commission.
See that?
And we say that policy envisages the use of force for crowd management. It prescribes that the use of force must adhere to gradual police response, which must be appropriate to the situation, proportional to the threat, reasonable to the circumstances, and minimal to accomplish the intended objective. And we refer to overleaf to the testimony of Colonel Scott, who explained that the use of force, as contemplated by this policy, is supposed to be a gradual use, starting with the employment of tonfas and tear gas, and increasing gradually, proportionate to the threat that is being met. So, if the members of the SAPS are permitted in law to employ some level of force, or which, in terms of that section, is referred to as a tactical option. The only requirement is whatever tactical option they choose must be proportionate to the threat. So it would not be necessary for the NMF to take that decision because it is part of SAP's operation. It is a call that is made by the operational commanders whether the situation requires the implementation of a tactical option. The only question then in the context of this inquiry that may arise is whether the decision taken related to their tactical option actually employed on the 16th of August. And we know that did not arise from the NMF. A question may very well be asked whether the extraordinary session took such a decision. And I will refer once again to paragraph 8 of our heads, where we accept that the findings of the Falam Commission stand as a prima facie case before you. And these are the findings of the Falam Commission insofar as the decision to employ the tactical option is concerned. And those we point out from paragraph 41 of our heads. And at 41.1, the Falam Commission pointed out that General Mbombo, in her testimony, had explained that she had expressed a hope that there would be a solution, but if this is not successful, my, meaning General Mbombo, intention was that we take the weapons. At 41.2, that's quoted from a section of the Falam report dealing with telephone calls made by General Mbombo at the conclusion of the extraordinary session. And over leaflet page 19 is a quotation from the Falam report, which states that it was inconceivable that Lieutenant General Mbombo would not, and we quote, have informed them of the important decision she made, which they had to implement the next day. At 41.3, again, the Falam Commission report confirms, in italics, the ultimatum had to go out, suggesting that he, and that's Mr. Monroe referred to there, already knew of Lieutenant General Mbombo's decision. At paragraph 41.4, and we are referencing at the footnotes all these references from the report. The report states that although it was strongly critical of the decision by the provincial commissioner to launch the tactical option on 16 August 2012, if the strikers did not voluntarily lay down their arms, sight must not be lost of the fact that her main desire was not for there to be a massacre or tragedy and for the strikers to be killed, but for the weapons to be laid down and the strikers to leave the copy. Once again, it confirms the finding that it's her decision. Having analyzed the evidence as the Commission did, it then, at 41.3, arrives at a conclusion, which we quote, and we say, the Commission, in rejecting the reason put forward by the SAPS as to the decision to implement phase 3 of the plan, and that's a tactical option, stated that, quote, what really happened was that the decision to launch phase 3 of the plan was taken by Provincial Commissioner Mbombo before or during a meeting at the NMF. In terms of this decision, the launching of phase 3 was to take place on 16 August. If the strikers failed to lay down their arms and disperse from the copy on about 0900 hours, and in brackets, as it was anticipated that they might, Now, members of the board, we submit that is the finding, and that's the prima facie case we have to meet, which is that General Mbombo took the decision. We are in total agreement with the Falam Commission in that regard, that General Mbombo took the decision. Consequently, it was not necessary for us to lead any evidence on that aspect, because we take that conclusion to be a reflection of the correct position. The evidence leaders then were required to make an election whether they agree with that finding and whether the evidence before the Falam Commission supported that finding, or whether they did not. Seemingly, they did not agree with that finding, and it is for that purpose that they called Captain Classen, the sole witness before this board who testified on this issue. And Captain Classen was then presented. We then deal with the evidence of Captain Classen in the next pages, from page 22 through to page 26. Captain Clatten's evidence is important in this regard. It's whether or not his evidence contradicts the prima facie case established. And his evidence would do so if it can demonstrate to the inquiry that, contrary to the Falam Commission's finding that the decision was made by Provincial Commissioner Mbombo, it was in fact made by the extraordinary session of the NMF. In that regard, Captain Ntlati informs us of what he heard Colonel Scott say to the commanders on the 16th at the briefing session.
Where do you refer to Captain Classen's evidence in your...
We start at page 23, Chair, and
paragraph?
51. Last sentence, we say it is the conclusion of the Falam Commission at paragraph 54.3 and 54.4. No, I apologize. We say it is the conclusion drawn by the evidence leaders in those paragraphs that prompted them to lead the evidence of Captain Classen. And overleaf, we analyze the evidence of Captain Classen. And we provide a quotation of the evidence he tendered during chief at page 24. We are all aware that Captain Classen said he heard Colonel Scott say the decision was that of the national management, full stop. It was not clear from his statement what he understood national management to mean. And in clarifying that point, Mr. Jamie puts the following question to him. Now, when Colonel Scott used the term, the national management instructed that the police must act, who did you understand he was referring to? So it clearly is his understanding, which doesn't come through his statement. And his response is, I understood to be all the managers of the policing are the ones who are instructed that there should be an action taken. That's his response. Advocate Jamie asks, you say all the management, who would that include? Again, he clarifies, I understood it to be the generals, and in their absence, those who will be in charge respectively. So what he understood is very clear now. Mr. Jamie moves on to ask a different question and says, when police talk about national management, who are they normally referring to? We submit that's a completely different question that has no bearing on his understanding, because he has clarified to us what he understood Scott to mean. And Mr. Ntlati's response to that question is reference is being made to national commissioners and divisional commissioners. Advocate Jamie then poses the question, national, is it correct that national you would understand to mean, or let me ask you a non-leading question, would national management include the police in Northwest? And the answer is no, it will not be referring to Northwest. Now, this is the latter part of that quote is a discussion about, in usual parlance, what the police mean when they say national management. And we will accept that that's what the police mean. Our submissions are that their usage of the term national management, at least on the evidence of Captain Ntlati, does not mean the NMF. Because on Captain Ntlati's own evidence, he excludes the Northwest. And we know the composition of the NMF is the National Commissioner and all provincial commissioners, including the Northwest Provincial Commissioner. So what the police normally mean when they say national management, this board cannot conclude it means National Management Forum because the evidence tendered by Captain Ntlati is absolutely wholly inconsistent with who and the makeup of the National Management Forum. And we believe that this confusion somehow, or this lack of clarity ensued during his testimony and finally settled by responses, or his answers to questions posed by the board, and in particular, the chair of the board. The chair poses a question to Mr. Ntlati, so you are sure that Colonel Scott referred to the National Management Forum during that briefing. Is that correct? His response is, Colonel Scott never referred to any station management or provincial management. What I heard him say is national management. That is why I noted it down. Now, what he means by the first part, it's not clear, but maybe it will then be clarified by his response to the next question by the chair. So you did not hear him use the word forum. His answer is, what he said is an instruction from national management, that is all. We submit, members of the board, that whatever National Management Forum is, or what it should be construed to mean, one thing it does not mean, at least on the evidence of this witness, is it does not mean the National Management Forum. This is the solitary witness that the evidence leaders relied upon to make the case that National Management Forum, or reference to national management, should be construed as reference to National Management Forum. Now, how that could be is beyond us, because the witness who heard the words does not extend it that far, and we have not heard of any basis on which the board must accept, contrary to what the witness says, that indeed it means the National Management Forum. So we say that settles the issue. And Captain Ntlati's understanding is important of what Colonel Scott said at that briefing. Because Captain Ntlati's statement was before the Farnham Commission. That statement and its contents was put before Colonel Scott. And Colonel Scott categorically denied that he ever made any reference to National Management Forum. At the time, the evidence leaders before the Marikana Commission stated, and we say so in our statement of response, that they will leave the issue at that juncture and call Captain Ntlati to come clarify the issue. And as we point out, in their wisdom, they elected not to call him. This is our first opportunity in this inquiry to get an understanding, therefore, of what Captain Ntlati says, and he has given us the understanding.
Captain Ntlati.
Ntlati.
You said Classen.
No, Chair, Ntlati. Ntlati.
Oh, didn't you? And then I misheard you.
As I said, Ntlati, Chair. So, his entire evidence revolved around his understanding. And there is no basis to reject his understanding for a preferred understanding he ought to have had. It's his understanding, he gave it to us, and that puts paid to the matter. In fairness to the witness, the testimony of Colonel Scott before the Farnham Commission was put to him by Mr. Jamie and says, this is what Scott said. And we say that is quite fair because he did testify that he did not follow Colonel Scott's testimony at the Marikana Commission. He was completely unaware of what Colonel Scott had testified to in this regard. So he was hearing for the first time what he said. So he's been granted an opportunity to comment thereon. One thing the witness does not say, he does not disagree with Colonel Scott's testimony. He does not challenge it. His response is very simple. I would not know how he testified, but I'm only referring or relating to what I heard him say in the briefing. That must mean Colonel Scott's evidence survives. It remains uncontroverted. The one witness who could controvert it in his own testimony does not. The conclusion must be that, in effect, there is no conflict between the testimony of Colonel Scott and the testimony of Captain Ntlathi presented before this inquiry. And consequently, the finding by the Farnham Commission that the decision to implement the tactical option was taken by Provincial General Mbombo must stand. The evidence leaders have not been able to persuade you otherwise or produce evidence to undermine that finding. That being the case, we proceed then from page 29 of our heads to say, we know the decision now is not the NMF decision, neither is it the extraordinary session decision. The minutes of the extraordinary decision, of the extraordinary session, are in the papers, and the summary of it is Provincial Mbombo briefed the attendees on the situation in Marikana, spoke of difficulties of capacity. The National Commissioner invited other provincial commissioners to assist with capacity where they can, and Provincial Commissioner Mbombo then proceeded to explain to the meeting what decision she had made and what steps she was going to take if the strikers do not disarm and leave the copy. And according to that meeting, the meeting endorsed her decision. Now, much has been made of that endorsement. And in fact, in argument yesterday, the evidence leaders went so far as to suggest that that endorsement constituted, to some extent, an authorization. The evidence leaders were kind enough in their statement of case to give us a definition of endorsement. And we have no quarrel with that definition. It is correct. And on that definition alone, the inescapable conclusion is one cannot endorse one's decision. You endorse another's decision. Implicit in that, therefore, is that by endorsing the decision, it could not be the National Commissioners. If the endorsement is to be interpreted as an authorization, then we submit that reference then must be had to the provisions of sections 207(4), section 12, and section 17 of 207(4) of the Constitution, section 12, and section 17 of the SABC Act, which inform us that the provincial commissioners exercise control and management over policing in their areas, in their respective areas. If the National Commissioner's authorizations is necessary before they can execute their constitutional duty and legislative duty, then we must be pointed to where the requirement for authorization is within the legislative framework. And our submissions, you will not find it. The proposition that it is an authorization, put simply, would suggest, in the absence of the authorization, the provincial commissioners cannot act. And that is inconsistent with the law as it currently stands, because they exercise full responsibility for what transpires in their provinces in regard to matters of policing, unless, in terms of section 17(5), they have been temporarily stripped of those powers by the president and the national commissioner put in command and in charge. So,
can I just ask a question? Because I think it has become clearer now that there has been constant briefing of the National Commissioner by Lieutenant General Mbombo. My question is, why was she constantly doing that? Why was she continuously briefing the National Commissioner?
The National Commissioner is her superior in terms of the structure of the SAPS Act. In her testimony before the Falam Commission, the National Commissioner was asked a similar question, which is why was she informing the Minister of Police about, or why did she inform the Minister of Police of what was transpiring in Marikana? And her explanation was that he is my political head. I'm accountable to him. I must inform him of what is happening in Marikana. On the same basis, the Provincial Commissioner keeps her abreast of developments in Marikana. Now, we may speculate, but we know that, in part, those briefings would be necessary because the Provincial Commissioner might have to request assistance through additional deployments. And then the National Commissioner would have a duty to act thereupon. The information sharing about what is panning out in Marikana and how the person responsible for that situation is managing it is not a report back to the decision maker on what to do about that situation. We submit it is to keep her informed about the unfolding situation in Marikana.
Is she then just a conduit pipe to the minister?
She is not a conduit pipe to the minister. Both she and Provincial Commissioner Mbombo are part of the structure of SABC. It is in their combined interests to be appraised of what is happening there. When she informs the Minister of Police, she's not a conduit pipe, because we know from the Marikana record that the minister himself directly communicated with Provincial Mbombo. And in fact, he spoke with Provincial Mbombo more times than he did with the National Commissioner. And that must suggest that his understanding was, to get a full picture of what is actually happening, I must talk to the Provincial Commissioner. There is no requirement in law that in order to get that understanding, he must go through the National Commissioner. And he exercised his right accordingly and directly contacted the Provincial Commissioner. Thank you. This then leads us to the question of concealment. And this question must be considered against the background of another question. What was being concealed? In the context of the term of reference, the only thing that could have been, that is being referred to, is a decision taken on the 15th of August. And it's either a decision of the NMF or a decision of the extraordinary session. By now, we hope we have persuaded you, with reference to the evidence, all the evidence available, that none of the two decisions exist. We concur with the Falam finding that it's a Provincial Mbombo's decision. So Consequently, if a decision does not exist, there is nothing to conceal. One can only conceal what is there. What is not there is not capable of concealment. To conclude that there was concealment, then this board would be invited to demonstrate or to conclusively show that a particular decision was being concealed. With reference, and firstly, describing that decision in full, and would have to arrive at that conclusion with reference to evidence. It is on that basis we submit that if you are with us, that a decision, whether it be the NMF or extraordinary session, does not exist, that the only decision at hand in relation to that tactical option is the provincial commissioner's decision, then according to the term of reference, the question of concealment does not arise. A different question arises, which we submit is slightly beyond the scope of the term of reference, is whether or not Provincial Mbombo's decision was concealed before the Falam Commission. And the answer to that must be a resounding no. The evidence is replete with reference to that decision, as demonstrated by the Falam Commission's own reference to the evidence in its report, repeatedly calling it the evidence of the Provincial Commissioner. Now, the question of concealment on our analysis arises from the Falam report, chapter 10, if it's at hand, part 9 thereof, page 185. And 185. And at para 6, line 3, it reads, the existence of the meeting and the decision was brought to the attention of the evidence leaders by a third party, and only after they had made specific inquiries about this meeting was the minute of the extraordinary session disclosed. Now, we have dealt with the issue of the third party bringing the information. That's Dirova. But what the commission states there is that Dirova brought to its attention the decision, both the meeting and the decision. And that is not to be found anywhere in Dirova's evidence. Dirova does not speak about a decision taken at a meeting. Reference there is to the extraordinary meeting. So Dirova doesn't testify to that. So that conclusion at paragraph 6 is factually erroneous.
Factually?
Erroneous. And that is further confirmed if I could find my reference. By the report at chapter 23, the chapter 23 starts at page 505. The particular section I would like to refer to is part C thereof, C for Charlie, at page 513, that's where it starts. And the heading of Part C is the consequence of the SABC's attempt to mislead the Commission. Now, at paragraph 4, the report states the following. The leadership of the police on the highest levels appears to have taken the decision not to give the true version of, one, how it came about that the tactical option was implemented on the afternoon of the 16th of August, and we suggest that be two, to conceal the fact that the plan to be implemented was hastily put together without POP input or evaluation. That is what is suggested was being concealed, not that a decision was being taken. On the same paragraph, it continues. In order to give effect to this, the decision at the NMF was not disclosed to the Commission. Two comments on that. In order to give effect to this, we say that is a reference to the decision not to give the true version, as the Falam Commission suggests. That's how it manifests itself. And it says, it is to give effect to this, the decision at the NMF was not disclosed to the Commission. And now we know it was not disclosed to the Commission because it was not there. It did not exist before the Commission at any point. So it could not be disclosed to the Commission because it was not there. And that again is confirmed by what now the Commission, as regards this whole issue about this decision, concludes at page 183, paragraph 2. And I will read for purposes of the record. That's page 183, Chair, at paragraph 2. It is now common cause, and we underline common cause, that the decision that the strikers would be forcibly removed from the copy by the police on 16 August 2012 if they did not voluntarily lay down their arms was not taken by the tactical commanders on the ground at Marikana on that day, but rather by Lieutenant General Mbombo, and was endorsed by the SABC leadership at an extraordinary session of the NMF held after its ordinary meeting was over on the evening of the 15th of August. It has now become common cause at this juncture. So, to further on at page 515, for the Commission to suggest, in order to give effect to this, the decision at the NMF was not disclosed to the Commission. That wholly contradicts its previous finding, as reflected in page 183. And we say, we invite this Board of Inquiry to prefer what is set out in 183 and the other relevant passages that we refer to, because that is wholly supported by the evidence, and to reject the decision of the NMF not disclosed as referred to at 515, because there is no evidence before this board regarding that decision. Now, if there was no decision and therefore no concealment, it's impossible, it's inconceivable there could have been a concealment. Then the third question is whether or not there was any misleading. Does the question even arise? And our simple response to that is it cannot arise. The question of misleading the Commission only arises if there is a factual determination of the decision as described and there is a factual finding of concealment. And we say, the conspectors of the evidence before you, those two questions can never be answered in the affirmative. The evidence leaders, even through the evidence of Mr. Ntlati, do not change that position, that factual position. Mr. Ntlati does not assist them in that regard. So the finding of the Falam Commission must stand, that decision was taken by the provincial commissioner, and therefore the question of misleading does not arise.
You've said that before.
And to the extent that, and again I will visit the question of, very slightly, and that is why I started with it, of, yes, Chair.
How long are you still doing?
No, I won't be longer than 10.
Can we ask you to terminate your submissions by 12:15?
Would that be 10, Chair?
Yes. Well,
Yes.
it's 11 minutes.
11? Oh, I'm grateful for the extra minute, Chair. And hence our submissions to you yesterday about the competent verdict. We suggest that to go the competent verdict route would be to suggest that if term 1 has not been established, for the reasons that we've set out, that the board is in a position to say, but hang on a minute, I am sure somewhere in the transcript and the evidence, there is something that we can find that, you know, you'll be guilty of. And I know that sounds a bit, that sounds facetious, but I make the comment simply to make the point that devoid of all the fancy words of competent verdict, that's what it boils down to. If term 1 is not established, that's the end of term 1, and we proceed to term 2. Now, term 2, originally we know it was worded in a fairly confusing manner, and it was officially amended, and now specifically calls on the board to consider whether the National Commissioner ought reasonably to have foreseen the tragic and catastrophic consequences which ensued of the decision to implement the tactical option. Now, based on the Falam report, we know that the decision to implement the tactical option was taken by General Mbombo, and in fact, that tactical option, as reflected in the plan that the Falam Commission finds was hastily put together on the 16th of August. And that reference, the board will find at page 514, paragraph 2. Which plan was criticized? That it was hastily put together without the benefit from inputs from experienced corps commanders and contained serious defects. Now, if we accept that that plan was born on the 16th of August, that plan could not have served before the National Commissioner on the previous day, Friday, because it didn't exist. The question of foreseeability, therefore, of the tragic consequences would not arise, because the tragic consequences arise from the implementation of that plan, which she at all times was not privy to. Now, what then she ought reasonably to have foreseen is not clear. And we submit in our heads, and we start that at page 34, that if you reject term 1, term 2 flows directly from your decision regarding term 1. If there was no such decision, she was not part of a decision, then the question of foreseeability does not arise on her part. It may very well arise in respect to other members of the SABC, like Professor Mbombo, who took the decision. But that is of no moment for now, because General Mbombo is not before you, and you cannot make any findings against her. The only thing we seek to persuade you on is that you cannot make a finding against the National Commissioner, against the evidence before you, that she foresaw or ought reasonably to have foreseen the consequences of a plan she was unaware of. And if one turns over, we have taken the liberty from page 36 of quoting the cross-examination of Advocate Bezos of the National Commissioner regarding the plan, which is the plan involving the tactical option. And then the responses unequivocally state that at that extraordinary session, no plan was presented to the meeting, no plan was discussed. And that is consistent with the evidence of General Basson, all the provincial commissioners who responded to the interrogatories by the Falam Commission, including General Mawela himself, who is the evidence leader's witness who specifically says no plan was discussed. On that basis, members of the board, we suggest that term 1 and term 2, based on the evidence placed before you, simply cannot survive. There is neither a factual nor legal basis to support them. And that brings me to the conclusion of my part of the argument, Chair. Thank you. Chair, if I may confer quickly, I see on my timing I have 6 minutes left, so I might put it to good use. Chair, I have conferred with my senior, and to clarify the point, he has requested me to read into the record a very small passage from the report. Page 514, paragraph 2, and I quote, "This decision," and that is the decision of General Mbombo, which is referred to in the preceding paragraph. "This decision meant that once it became apparent that the strikers might not lay down their arms and disperse, the plan which had been developed in 13 to 14 August and approved by the JOCOM could not be implemented, and a new plan had to be prepared. Unlike the earlier plan, which was relatively risk-free, the new plan, which had to be prepared in haste, did not benefit from inputs from experienced POP commanders and contained serious defects. It had, moreover, to deal with a very different situation from the one for which the earlier plan had devised, and there was a distinct risk of significant bloodshed, which was in fact foreseen by some of the senior subs commanders." And we suggest that those commanders on the day who were privy to that plan. At 1330, which is the next paragraph, where there was no sign of the strikers being willing to lay down their arms and disperse, the Provincial Commissioner ordered Major General Annandale to implement the tactical option. At that stage, the new plan had not been discussed by the JOCOM. The planner, Lieutenant Colonel Scott, put the details before JOCOM from which its POP members were absent. There was no challenge process, and Lieutenant Colonel Scott and Brigadier Pretoria went to FH1 to brief the commanders. There was no time to prepare the hard copies for the commanders, and they were shown an image based on the earlier plan on Lieutenant Scott's laptop computer and orally given the details of the plan. The implementation of the plan had catastrophic consequences which resounded all over the world. It is that plan which had the catastrophic consequences, and the term 2 refers to whether or not the National Commissioner ought to have foreseen the consequences of that plan. Just another second to confirm. Thank you, Chair. I've confirmed. That concludes my part of the argument.
Mr. Mukari?
Thank you, Chairperson. Chairperson, before I start, I'd like to ask my attorney to distribute a bundle which consists of the legal prescripts which I'm going to read from. Can you do that, please? To the members of the board and to our opponents. It is actually a bundle which consists of the public service regulations and other regulations which I'm going to refer to. whilst it is a bundle which has an index, there will be two documents which are stapled together, which are not bound to the bundle, and that will be the Public Service Act and as well as the Public Service Regulations.
Thank you.
Members of the board, the reason why I'm distributing this bundle, it is because of, yes, the attorney will make sure that our opponents also get the documents, the bundle.
Well, I think they should have it now,
But
before you commence.
Would it be helpful, Judge?
yes, I understand that.
So can you distribute to them as well?
Yes, I understand that. I mean, I accept that. You know, I should have done that earlier. So I have
Have you only given them one copy?
the public. Chairperson, because these are just legal prescripts, it's a legislation. So I just put the bundle together and asked my attorney to do so as well. So it was for the benefit of the members when I read the relevant sections of the Act and the relevant sections of the regulations.
And
So-
this
so
bundle
it's-
two,
so it's
have
all-
you given them a copy of this bundle too?
Indeed, that would be helpful, yes.
Have you got it, Mr. Chairman?
I have no idea, Judge. I'm sorry. What you've been given, I've been given a copy of the Public Service Act and I've been given a copy of the Public Service Regulations.
No.
Could I just inquire whether these, I don't have that, no.
He doesn't have that.
Yes, indeed. Then I think that's why then the judge was saying that whether he can offer the bundle, because the Public Service Act and the Public Service Regulation have been given to the members of the board separately. So that's what you have, but you don't have the bundle which has the South African Police Service Regulations and the disciplinary code of the public service. So that's what the judge is offering to give to you.
The judge is not offering to give it to me. I don't think you are offering to give me anything, Judge.
Or you want to know if you have it.
Mr. Mukari, this document, Mr. Mukari, this document that you have given to us, 3 copies, one for me, one for my two, each commission, must be given to them as well. They must have a copy of this as well. Now,
Yes.
where is that?
Oh, I understand that my attorney is working on that.
No, but it must be given to them now.
Yes, indeed, Madam Judge. That's why I'm saying that I informed my attorney to make copies. Apparently, she didn't make enough copies, but as I understand, they are attending to that.
So, Judge, it doesn't help. It seems Mr. Mukari wants to proceed. We're being put at a terrible disadvantage. My juniors have not been given copies. If these are not in the heads, as I surmise they are not,
Oh, there they give them.
then we need them to follow the argument.
No. This is not problem, Mr. Mukari. This is not collegial. There are 3 council there. They're entitled to each a copy of all the documents. Please, I mean, that's been the procedure all along. And they've given you copies for each of your council, and I think the proper thing is for you to give them each a copy of the documents that you want to refer to.
Yes, no, it looks like we don't have sufficient copies. I don't know if the members of the board would like us to adjourn maybe for 5-10 minutes, then we can make those copies. My attorney can make those copies. I think it was an error on the part of my attorney not to make enough copies.
But
So I
Mr.
thought I would-
Mukari, you knew about this. You knew that you were going to refer to these documents. They should have been prepared for the defense, for the evidence leaders before you commence your argument, surely.
Yeah. No, I accept it. I'm not taking issue with it.
Sorry, Judge. We're prepared to attempt to go on because I don't want to waste time. So we'll carry on.
I'm going to give you one copy here. We have 3 we can share. So we're going to give you one copy. Just give that to them. We'll use 2 copies.
Thank you, Judge.
But for the record, this is not proper. Carry on with
So understand that now they have the copy. Oh, in fact, my junior informs me that this bundle was distributed to the evidence leaders yesterday. Eh? Oh, then I'm told that they just got it now, so it's fine. Can I start now?
Yes, please proceed.
Now, members of the board, I am dealing with the last 3 charges, which are identified as term of reference 2.3, 2.4, and 2.5. Before I do so, I deemed it necessary that I should put together the legislative instruments which will put the correct legal position to this disciplinary inquiry, in particular with the necessary import which must be given to it as a labor or employer-employee relationship. You remember, Chairperson, that when the evidence leaders addressed you, they actually said that we have not responded to the allegation regarding the National Commissioner's breach of the disciplinary code. I think you remember that. In fact, you'll find that in the statement of case, I'm moving from the premise that the statement of case is before the members of the board.
Yes, it is. The evidence leader's statement. Okay.
The evidence leader's statement of case.
Yes, we have it.
So, if I take the members of the board to page 25 of that statement of case, there is a heading there, it says basic values and principles governing public administration. Paragraph 33 of that statement, they say, the National Commissioner as the head of the SABC is part of the public service for the Republic. Chapter 10 of the Constitution in turn prescribes the basic values and principles governing public administration. Within the public administration, there is a public service. Section 197 of the Constitution stipulates that the public service must be structured in terms of national legislation, and its terms and conditions of employment must also be regulated by national legislation, which in this case is the Public Service Act. Now, we know that in an employment dispute, employer and employee, when an employee is charged with misconduct, as it has happened in this case that the National Commissioner is charged with acts of misconduct, it is the duty of the employer to identify the rule that has been breached. And that is precisely what the evidence leaders are seeking to do here. Then when you, at page 26, so now we know that they say that their source is the Constitution and the Public Service Act. And then at the bottom of page 26, they have the Code of Conduct for the Public Service. Paragraph 35. They refer you to Chapter 2 of the Public Service Regulations. And when you turn to page 27, paragraph 36, they then itemize the provisions of the Code of Conduct which they say are applicable to the National Commissioner and which she has actually breached. And in fact, then this is what the evidence leaders have been submitting, and that goes up to page 28 of that document. Now, let us turn to our statement of response. You will remember that we were criticized by the evidence leaders that we paid lip service to these allegations, which starts at paragraph 33 to 38.8 at page 28. And indeed, we deal with that in our statement of response. So if I can turn to page 31 of the statement of response, paragraph let's say paragraph 83. Or we can take it from paragraph 82 at the top. Because in paragraph 82, we are responding to paragraphs 33 to 34, where then they are referring us to the Public Service Act. Our response there was, the contents of these paragraphs are of no relevance whatsoever to the inquiry conducted strictly in accordance with the terms of reference set out in the schedule. Insofar as we responded to the Code of Conduct for the Public Service, our response appears at paragraph 83, and there we said, the reliance on the provisions of the Public Service Regulation, the Public Service Act, and the Code of Conduct for the Public Servants is completely out of place and finds no relevance in the context of the terms of reference which are binding on this inquiry. So what we're doing is this. We're saying to them that this inquiry has been set up by the President in terms of Section 9 of the South African Police Service Act and not in terms of the provisions of the Public Service Act. The provisions of the Public Service Act are not applicable at all in this inquiry, and they are also not applicable to the National Commissioner. The Public Service Regulations which they are relying on, which they say that the National Commissioner has breached, are not applicable to the National Commissioner. The Code of Conduct that they're referring to is not applicable to her. The SMS Handbook, which is the Code of Conduct for senior managers in the public service, is not applicable to the National Commissioner. So the premise for these charges are on the wrong footing. I'd like members of the board to have in their position the bundle that I've handed up, which I said that I'm going to refer to as the authorities bundle in order to demonstrate the point I've just made to you. Let us start with page 21 of that bundle.
Page 21.
Page 21. If the members have page 21, you will see there that the document there is regulations for the South African Police Service and the Scheduled South African Police Service Employment Regulations, 2008. So now these are the regulations which have been promulgated by the Minister of Safety and Security, which we know is the Minister of Police, and in terms of the South African Police Service Act. When you turn to page 23 of that document, under Chapter 1, It tells us what an employee is, that an employee means a member of the service as defined in Section 1 of the Act. And the Act, of course, then is defined as the South African Police Service Act. And paragraph K tells us what the minister is. The minister means the Minister of Safety and Security. And then paragraph N, it tells us that the Public Service Act means the Public Service Act as promulgated by the Proclamation 103 of 1994. And SMS means employees appointed to a post-level grade of 13 or above. And the Act is the South African Police Service Act. And these regulations are these regulations of 2008. So that is what we know about the South African employment regulations. Then when you turn, so you just leave it for a moment and go to page 53 of that document. At page 53, we have chapter 5, which is then of the senior management services, and it tells us about the establishment of SMS. It says the National Commissioner must create an appropriate number of posts at senior management level. And then from there, then it tells us about other provisions, but 64 at the bottom, paragraph 64 says, handbook for SMS. The minister may include any or all of the determinations, directives, guidelines, and provisions applicable to SMS in a handbook for the SMS. Then when you turn the page over to page 54, then paragraph 68, it tells you about employment contracts. It says a person newly appointed to the SMS other than the National Commissioner must within 2 months then of his or her appointment conclude a contract of employment. But then
which one are you reading now?
Page 54.
Yes, section?
Paragraph 68, which is section 68. And I was reading sub 1, but now I'm coming to sub 2 because sub 2 is relevant to the National Commissioner. Is that the National Commissioner must, as soon as reasonably possible, after his or her date of appointment, conclude a contract of employment which must be based on the provisions of the contract set out in Annexure 1. And then from there, then paragraph 70 at the bottom, which says determination of conditions of service. So the minister must annually make determinations regarding the conditions of service of members of the SMS. And we know from the definition that I've read of the minister that the minister means the Minister of Police. Now, when we turn to paragraph 77 at page 56, it deals with misconduct and incapacity. The minister may, subject to the Labour Relations Act, issue directives to establish misconduct and incapacity procedures for members of SMS. So it means that it is the duty of the minister, subject to the Labour Relations Act, to issue those directives. Then when we turn to page 59, then this is just a template of how a contract of employment with the National Commissioner should look like. But then, so let's leave that for a moment then and come to page 79. At page 79, we have now the South African Police Discipline Regulations. Page 79 is the South African Police Discipline Regulations. What is important that I would like to highlight then in respect of the definitions there is definition of employer. It says employer means the National Commissioner or any person delegated by him or her to perform any functions in terms of these regulations. So now, the submission I'm going to make later, which tallies with what I have just read, is that the South African Police Service Discipline Regulations, as we have pointed out to you yesterday, will not be applicable to the National Commissioner because she's the custodian of them. So she's the employer, and then she's the one then who ensures that discipline of all members of the force are disciplined in accordance with this South African Police Discipline Regulations. But then when you turn to...
Including the National Commissioner?
Excluding the National Commissioner.
Excluding? Excluding.
She's the employer, so she can't discipline herself. So she's the one who implements the South African Discipline Regulations. So then when you turn to paragraph 2, that is now page 80, scope of the regulations. Sub 1 says, Based on the agreement reached between the employer and all the unions admitted to the Safety and Security Sectoral Bargaining Council, these regulations apply to the employer and all employees falling within the resource scope of the council. But 2 then says, these regulations also apply to members of the senior management service of the service, excluding the National Commissioner and the Provincial Commissioner. And I'll come to why it is so, excluding these 2. Then we can then leave that now. Let's come to page 99. Page 99.
Page 99.
Yes, page 99. Now, page 99, we've included, that's right, is chapter 7. That is now chapter 7 of the Code of Conduct for Senior Managers. It is an extract from the SMS handbook, so what is famously known as the SMS handbook in the public service. Then chapter 7 is included because it deals with misconduct and incapacity. Now, senior managers in the public service are disciplined in terms of chapter 7 of the SMS, which is misconduct and incapacity.
I see that we start at page 2 on page 101 of this Code of Conduct. Is page 1 relevant or not?
Page 1 simply says chapter 1. Then simply has the headings chapter 7.
I don't have that.
Then the next page.
The judge's one doesn't have.
Oh, it's one of those. Oh,
I see my colleague has it.
oh, you have it. Oh, thank you very much. Thank you. Sorry about that, Judge. So page 2, the principles, and then it sets out in the principles of discipline, the scope of application, and then when you turn to the next page, then it's the code, rules, and standards. 2.5 says procedure, disciplinary action.
You've given me a copy where only one page has been printed. The other
On
page
one side.
in all of them have not been printed. They're
Oh,
all-
I
I'm not sure
profuse
if the
the...
same is with
Mine is the same, Judge.
as mine.
It's only even pages.
Yeah.
Just the even pages, 2, 4, 6, 8.
So,
Then I photocopied one side.
yes.
Okay, I'm not going to read this. I'm going to leave this one. I'm going to leave this one, and then come straight to. So put this bundle aside.
Yes.
Those portions that I wanted to refer you to, I've referred you to them. So let's put it aside. Let's now take the Public Service Act. That one I handed it separately.
Yes.
Now we know that the South African Police Service discipline regulations exclude the National Commissioner and the Provincial Commissioner. So the question that must linger for now is, now, in terms of which prescripts are they to be disciplined? Now let's look at the Public Service Act. The Public Service Act is the legislation that governs the employment, terms and conditions of employment of public servants. And that we see at section 2, application of Act. But before we actually look at section 2, let's look at section 1, because section 1 is important. It deals with definitions, but definitions are very important. Let's look at the definition of minister on the second page. It says minister means the Minister for the Public Service and Administration. So we know that in terms of the Public Service Act, when it says minister, it refers to the Minister of Public Service and Administration. Then section 2 says, except insofar as this section provides otherwise, and except where it is inconsistent with the context or clearly inappropriate, the provisions of this act shall apply to or in respect of employees whether they are employed within or outside the Republic, and in respect of persons who were employed in the public service or who are to be employed in the public service. Now, subsection 2 is the most important one. It says, where members of the services, and I like, for present purposes, members of the board to underline services, because I'm going to come back to it. Where members of the services, educators, or members of the intelligence services are not excluded from the provisions of this Act, those provisions shall, subject to subsection 2A, apply, and I'd like members to underline the remaining part, apply only insofar as they are not contrary to the laws governing their employment. So, the provisions of the Public Service Act is applicable to members of the service only insofar as they are not contrary to the laws governing their employment. Then, if we can then look at the provisions that deal with discipline, that will be section 16B. The heading there says discipline.
16B.
B for boy. B, and I refer in particular to subparagraph 2 on the next page. An employee of a department other than a member of the services, an educator,
That's part
and again,
of section 17. At the bottom you will see section 17 starts with termination of employment.
Indeed, I'm sorry.
And you're now reading from subparagraph 2.
Indeed. Thank you very much, Judge. So subsection 2 says, an employee of a department, again I'd like members of the board to underline, other than a member of the services. An educator or a member of the intelligence service may be dismissed on account of, then it tells us, incapacity, operational requirement, and so on, misconduct. And in subsection 3A, Roman figure 1, it says, an employee other than a member of the services, or an educator or a member of the intelligence services, who absents himself or herself from his or her official duties without permission of his or her head of department, office or institution for a period exceeding 1, and so on. But again, I'd like members of the board to underline in subsection 3A, Roman figure 1, an employee, and then underline other than a member of the services. Now, let us come to the regulations, and I've handed up the regulations also as a separate document. This now Thank you very much, Chairperson. So I was taking you to the Public Service Regulations. I've shown you the Public Service Act. These regulations, the separate document which was handed up, are actually promulgated pursuant to the Public Service Act. They give effect to the Public Service Act. Now, the Public Service Act, we know that it defines who an employer is. That is an executive authority responsible for that department. And when you look at the Public Service Regulations, then we turn to then page 3. The regulations are numbered at the bottom right. The page numbers are at the bottom right. So we go first, then we look at the interpretation, page 7. What normally in the Act it will be referred to as the definitions. So what you will not find in the definitions or interpretations provided here will be of an employer, but you will have at least then the interpretation or definition of executing authority in paragraph E, which says means the executing authority as defined in section 1.1 of the Act. And when we go to section 1.1 of the Act, and the Act is the Public Service Act, then it tells us about that it is actually then the responsible minister for a particular department. Then let's turn now to SMS, definition of SMS at page 8, paragraph R. SMS means the employees referred to in Regulation 1B.1 of Chapter 4. And then as the Act means the Public Service Act. So if we can then turn to Chapter 2, page 42. Because I just want to go straight to it, because these are the provisions that the evidence leaders have referred to in their statement of case that the National Commissioner has breached. Chapter 2, page 48 says Code of Conduct for the Public Service. So that is the Code of Conduct that you've been referred to in the statement of case. Paragraph C, Code of Conduct, that is paragraph C, which has been quoted at page 27 to page 28 of their statement of case. It says, a relationship with the legislature and the executive, it says, an employee, C.1.1, is faithful to the Republic and honors the Constitution and abides thereby in the execution of her or his daily tasks. C.1.2 says, puts the public interest first in the execution of her or his duties, and that's what they say she has breached. And then when you turn to page 43, then they also then quote all the provisions of paragraph C.2 of relationship with the public, and they say that these are the provisions which she has breached by her conduct. Now we know that these public service regulations, which are promulgated in terms of the Public Service Act, are not applicable then to the members of the service, and then they are applicable to the public service. Now, what is the service? Let us go now to the Constitution. It will tell us what a service is. If we can go to, first let us start with Chapter 10 of the Constitution, section 195. The heading there says public administration, and then section 195 is basic values and principles governing public administration. Now, when one reads this, it then becomes pertinently clear that the Constitution makes a distinction between public administration and public service. Public administration is broader, whereas public service is specific. But then let us look at section 195, which is applicable to public administration, for which the public service is one or included. that it applies to all, we see that as subsection 2 of section 195, it says, after subsection 1 has mentioned the basic principles which the public administration must adhere to. In subsection 2, it says the above principles apply to A, administration in every sphere of government, because it's the entire, and then to B, organs of state, and C, to public enterprises. So we know from the reading of the Constitution that a reference to public administration is the entire government, departments, and including organs of states and enterprises. That is why then we will then have a section separate, which is section 197, dealing with the public service. So now, section 197 is the one that they say that the National Commissioner ought to have also then adhered to, and it says that subsection 1, within public administration, there is a public service for the Republic which must function and be structured in terms of the national legislation and which must loyally execute the lawful policies of the government of the day. Subsection 2 then says, the terms and conditions of employment in the public service must be regulated by national legislation. Employees are entitled to a fair pension as regulated by national legislation. And then from there, then it mentions then other provisions, subsection 3 and 4, that no employee of the public service may be favored and so on. But then what we have now is we know that within the public administration, there is a public service. But what the public service did not tell us about is that the police are part of the public service, and we say they are not. That is why you'll find the police under Chapter 11 of the Constitution. A completely different chapter. So in fact, then, just to make it clear, under section 197, subsection 2, where it says that the terms and conditions of employment in the public service must be regulated by national legislation. That national legislation is the Public Service Act, which we have already referred to. Then in Chapter 11, we have security services. Now let's see, according to our Constitution, what is security services in our government? Section 199 is quite opposite. Establishment, structuring, and conduct of security services. Then subsection 1 says, the security services of the Republic consist of a single defense force, a single police service, and any intelligence services established in terms of the Constitution. Now, when you read this section, section 199, subsection 1, with the provisions that I have referred to of the provisions which have said that members of the board should underline where it says except for members of the service. So these members of the service are here regulated by the Constitution in terms of Chapter 11, and section 199(1) makes it patently clear where the police force is located in the scheme of our administration. So now what we have now is the National Police, then the National Commissioner of Police, who has been accused of having contravened the provisions of the Public Service Act and the Public Service Regulations, and a whole of noise is made about how she answers to those questions, and criticized when she says that those allegations are completely inappropriate to the terms of reference of this board, but the terms of reference of this board must be informed by the code that is applicable to the National Commissioner. Now let's sit back and ask ourselves this question. Now that we know that the Public Service Act is not applicable to our terms and conditions, now that we know that the Public Service Regulations are not applicable, now which regulations are applicable to her, because even the South African Police Service regulations are not applicable to her, because she's the one who must actually implement them. In terms of the South African Police regulations, she is the employer, and she's the one who must discipline. So what legislative framework must be used to discipline her? There is only one left, Section 9 of the South African Police Service Act, and nothing else. So let us now then come to Section 9 of the SAPS Act. So Section 9 of the South African Police Service Act, it deals with misconduct by or incapacity of national or provincial commissioner. Now, members of the board will know why it is written this way. It is written this way because the South African Police Service regulations, which are supposed to regulate the employment and the terms and conditions of the police force, exclude the national commissioner and the provincial commissioner from the application. So they can only be dealt with in terms of this section, and they're the only ones who are mentioned here and no other, because the other members of the force are dealt with in terms of the South African Police regulations. Then it says that subject to this section, subsections 1 to 8 of Section 8 shall apply mutatis mutandis to any inquiry into allegations of misconduct by the national or provincial commissioner, or into his or her fitness for office or capacity for executing his or her official duties efficiently. So this is the provision under which this board operates, under which this board then derives its powers, and then we know that in terms of the terms of reference set out by the President, then he has done so expressly in terms of Section 9, giving effect to this board to interrogate the terms of reference which he said that the board must do and submit a report to him in terms of Section 8, subsection 6 of the SAPS Act. This is the only legislative instrument, and the evidence leaders a contention that she has breached the Public Service Act and therefore she must be held accountable is completely misplaced. On that note now, I turn to the charges as they've been framed, and I would like to go straight to charge 2.3 as it is set out in the term of reference. Given the fact that this board operates strictly within the confines of the law, the empowering provisions that have been given to it, so it is important that we must not be overtaken or become overwhelmed by emotions, but we must remain calm and focus on the work that we are supposed to do, which is to read the charges and then deal with the charges as they are. So when you look at 2.3, 2.3 is very specific, is a charge that cannot be misinterpreted. It is so clear. It says that the remarks by the National Commissioner at the SAPS parade on 17 August 2012 would have been understood to be an unqualified endorsement of the police action and thereby having the consequence of undermining, frustrating, or otherwise impeding the work of the Commission. Now, a charge is an allegation of wrongdoing. So there is an allegation of wrongdoing which must be identified, or it must be clearly identifiable so that this board can be able to deal with it in the context of the evidence that is before it. So let us look at what is the charge here, because then what we have here is a paragraph. The remarks by the National Commissioner at the SABC parade on 17 August 2012 would have been understood to be an unqualified endorsement of the police action. And then the charge now starts, and thereby having the consequence of undermining, frustrating, or otherwise impeding the work of the Commission. There seemed to be nothing wrong when one looks at this charge in the National Commissioner addressing members of the force and giving them a particular statement of what she believes to be the truth. But what becomes a charge is if what she communicates to them, as the chairperson has indicated in engagement with one of our members here, of our colleagues, what becomes a charge is if then that had the effect of the consequence of undermining, frustrating, or otherwise impeding the work of the Falam Commission of Inquiry. And this board is going to find that Falam dealt with that in chapter 14 of the report.
1.4.
1.4.
Page.
I'll come to that. That will be page 388.
388.
Yes, 388.
Thank you.
So it is a separate chapter on its own. It's a very short chapter. It consists of only 4 pages. And the heading at the top says, the SAPS parade on 17 August 2012. Members of the board will have seen in the statement of case by the evidence leaders have corrected the date to say that whilst Falam has attributed the remarks which have been made by the National Commissioner to have been made on the 17th of August, but in actual fact that happened on the 20th. In our statement of response, we said, yes, that is true, because then as a matter of fact, when you look at the statement, indeed that statement was made on the 20th, and we take no issue with that. We also accept that it could have been one of those obvious errors in the report. So any reference to the 17th in paragraph 1 at page 388, then it could as well then read to be a reference to the 20th, but only insofar as the statement made by the National Commission is concerned. Because the statement that is quoted at page 389, which was made by the minister, it remains to have been made on the 17th. So we should then make that, make that distinction. So the statement by the minister is correct. It was a statement made on the 17th, but then the statement by the National Commission at page 388 was made on the 20th. So then that is an obvious error then which require then that correction, and there shouldn't be any problem with that. But then we have to now look at whether Falam has made a finding in respect of this parade of the 20th in relation to the statement that was made by the National Commissioner.
And that's in paragraph 2 of the report.
And that is now in paragraph 2 of the report. That's that statement. I come before you actually and so on.
Yeah.
Then from paragraph 3, then Falam then deals with it and says, when one bears in mind that the statement was made on the day after 34 civilians had been killed by members of the SABC, and the President announced that a commission of inquiry would be established. The statement that whatever happened represents the best of possible policing was singularly inappropriate because it set out what was from then on to be the official police line. That no blame at all attached to the police for what happened because they had been responsible in doing what they did. This was calculated to effect a closing of the ranks, encouraging those who had participated in the operation to withhold contrary information from the Commission and indeed to deny that mistakes had been made and things had been done that could not be described as the best of possible policing. Then paragraph 4 then importantly says, the National Commissioner clearly did not, and to be fair, and that is what we'd like to, then I'm members of the board then to underline, and to be fair, could not know all the relevant facts, and she exposed herself to a cross-examination in which she cut a sorry figure when things that had happened and which were recorded on video or in photographs were shown to her, and she was asked whether they represented the best of responsible policing. So then what Judge Falam does, then from there he deals with a statement by the Minister of Police, and he deals with it now after quoting it at paragraph 6. He says, the Minister did not go as far as heaping praise on the subs for the best of responsible policing, but his exhortation to the police to continue ensuring that lives are saved and his words are commendable for what they were doing were also calculated to bring about a closing of the ranks and to discourage any subs member who was minded to tell the Commission that things had not gone as well as they must have hoped they would. The Commission appreciates that the Minister and the National Commissioner may well have been confronted with what appeared to be a serious lack of morale on the part of those involved in the operation, and that they would have considered it necessary to address that. But it was not, in the Commission's view, but it was, in the Commission's view, a serious error of judgment on their part to go as far as they did in giving what would have been, and would like members of the board to understand, would have been understood to be an unqualified endorsement of the police action. Because there was no evidence that was laid before Falam to prove that when they were uttering these statements, and in particular the National Commissioner, the intention was to mislead, to impede the work of the Commission which was coming, and that it was an unqualified endorsement. That the only conclusion that Falam could reach is that it would have had that effect. But he gives a qualification to that first they didn't have all the information. And he concludes by saying that at the end, that's paragraph 7, while the Commission cannot find, as the evidence leaders suggest, that it is likely that the Minister and the National Commissioner discussed the approach in advance, it is firmly of the view that his remarks and her remarks were ill-advised and may well have had the result of hampering the Commission in its work for the reasons stated above. And you'll find nowhere in the report by Falam where Falam says that he was unable to perform his functions because then this has actually impeded his work. So he's simply saying that these are ill-advised statements, and these are the type of things that both the National Commission and the Minister should be careful of in future. So we say in our statement of response, and also then in our heads of arguments, an error of judgment of what people say in life, how can that be elevated to misconduct? When we say that errors of judgment are made by everybody, judges make errors of judgment. That's why their judgments are taken on appeal. Sometimes they are found to have even acted irrationally. And why are they not asked then to be disciplined or to resign? It is a completely inapposite statement for one to say that an error of judgment should lead to one then being now then disciplined, because Falam did not elevate it beyond anything. That's why I said that if he would have found that there was a collusion between the Minister and the National Commissioner, that they wanted to deliver this particular message so that the Commission of Inquiry which is going to be set up does not come to the truth, then that is a serious matter. If the evidence leaders wanted to elevate it beyond what Falam has done, it was incumbent upon them to lead evidence to that effect. And that evidence was not led, and therefore we say that nothing has arisen from this charge requiring this board to find her guilty of this charge. So if I turn now then to the fourth term of reference, which is 2.4. Yes, indeed. 2.4 then, it deals with now the report prepared by the National Commissioner for the President of the Republic on the 16th August 2012, and the media statement subsequently issued on 17 August 2012, was deliberately amended to conceal the fact that there was 2 shooting incidents, scene 1 and scene 2, resulting in misleading the public that all the death had occurred at scene 1, which arose out of members of SABC having to defend themselves from an advancing mass. Again, this charge has been completely misconstrued by the evidence leaders. As evidence to that they completely misconstrued this charge, they brought Mr. Mashego to come and testify to this board about the changes that he said were made by him and Adrio, and the further changes which were made by the National Commissioner. But where did that take us insofar as this board is concerned? Because when one looks at this charge, it has nothing to do as to who made the changes and which changes. Falam, in chapter 15, which we'll come to, is very specific as to what his complaint is. His complaint is that this statement, and he's very specific about the statement I was talking about, is a media statement. The media statement which was read out by the National Commissioner on the 17th of August, that media statement, contrary to what the internal briefing did, showing the president that there were 2 scenes and that the shootings happened in 2 scenes, the media statement only portrayed that it is 1 scene and all the people died in 1 scene. That is what the charge is about. It's not about that the National Commissioner has made changes and which changes and so on. In fact, I would have expected the evidence leaders, if they wanted to bring Mr. Mashego here, for Mr. Mashego to come and testify about the deliberate amendment in order to conceal. That's what he was supposed to deal with. And the evidence of Mashego has not even touched on that. Nowhere will you find the evidence of Mashego where he's saying that when the National Commissioner made those changes that he said that she made, she said that then the purpose is that we don't want the public to know 1, 2, 3 or to know the truth. He doesn't go there. He's simply saying that the National Commissioner dictated these changes and he identified them in paragraph 5 and paragraph 6 of the statement. And so how does it help the evidence leaders insofar as this charge is concerned if he does not talk to that the intention, because deliberate goes to intention, that the intention was to remove those portions so that the public does not know the truth. That is not what then Mr. Mashego then is saying. So what this board is left with, insofar as this charge is concerned, is the evidence that was led before Falam.
But it was not for Mr. Mashego to decide what the intention was. It's for this board to decide what the intention was with those amendments.
Indeed.
By a process of inferential reasoning.
Indeed.
This is our task.
I take no issue
not
with that.
Mashego.
I take no issue with that. All what I'm submitting is that this board, in order for it then to come to that conclusion, it must analyze the evidence. So there must be evidence that is there for it to analyze. So what has to be analyzed is the evidence. So I'm saying that on the evidence of Mashego simply come to say that the National Commissioner then made these changes, and then the other changes then were made by me and Mr. Adrio. But the chairperson has correctly actually pointed out to me, when I was cross-examining then Mashego, that insofar as the media statement is concerned, it is for this board to interpret the document objectively. The chairperson actually went further to say to me that even Mr. Mashego's understanding will not play any role because his understanding is irrelevant because it is a document which must be interpreted objectively. And in fact, when the board looks at how Falam dealt with this, he dealt with it by simply looking at the 2 documents. Because then the evidence, then whoever comes to the evidence, it becomes really irrelevant. Because he simply looked at the 2 documents, and then he interpreted them, and he then came to the conclusion that this document, which is the media statement, only shows that there was 1 scene there. So let me then take it further to show that the evidence of Mr. Mashego was completely irrelevant to the charge. During the interaction between the National Commissioner and Falam about that, that's I think the day 105, about the media statement, the National Commissioner say to Judge Fanam, I accept that it is my statement. I mean, I own it. I mean, let's go to the statement actually. You'll see that the statement is written in the first person. It's not a statement which is written on as if then is we and so on. So it says, I, as a National Commissioner. So it is her statement, and then she actually then accepts what is in that statement. She can't divorce herself from the statement because she was reading that statement as the National Commissioner. So that must be the point of departure. The inquiry then must be, the statement, when you read it, did it conceal to the public? And that's what I want to do because that is what the charge is about. I'm not interested in Mr. Mashihu, who came here and told this inquiry that the reason why he came here is because he wanted to clear his name that he had the National Commissioner implicating him that he drafted F4. The F4 which the Commission, the Farm Commission did not have an issue with. In fact, F4 is a document that the Farm Commission departed from as the truth. That when they look at 444 is a document which talks the truth. Then you come with F5, which is misleading. That's basically then what is happening there. Now, he says that the reason why he came to testify is because the National Commissioner implicated him that he drafted F4. What is the value of that? It was something else, members of the board. If he said that, I came to testify because I had the National Commissioner implicating me that I drafted F5. Because F5 is the one which is implicating, is the one which then is found to have misleading statements. So what is the value of Mr. Mashihu's evidence, who came here precisely to clear his own name? But I'll come at the end just to show how incredible Mr. Mashihu's evidence is when one even looks at the evidence of his own subordinate, Mr. Adru. That when you read the statement of Mr. Adru, you read the statement of Mashihu, you'll wonder on what basis the evidence leaders will want to rely on both of them. Because the statements are mutually destructive. But let's not really then get taken by the evidence of Mashihu, which was not addressing the charge. Let's look at the charge by looking at the documents, the two documents. Then you'll remember that the two documents are contained in Exhibit B. Can we have then Exhibit B with us?
Yes. Exhibit A. Oh, there's B. There's B. Here we are. We have it.
Thank you, Judge.
And if I remember correctly, the two statements that we looked at was at page 140
Yes.
and at 138.
Yeah, that's right.
37 and 38.
Yes. So first we're going to look at the statements, and then from there we go to the report of Falam and see what Falam says about them. So that's page 140 is the statement which was identified as Exhibit F5. Exhibit F5 is 137.
140 is the one that was sent to the President. And
Yes.
137 and further is the media statement.
Yes, that's
under
right.
the name of General Phiyega.
Yes, that's right. In fact, what we must do in order to undertake this exercise, let's do it this way. We have page 140 in front of us. Let us then open chapter 15 of the Falam report and put it on the side as well.
Page of the Falam report page.
Yeah. This is yours now. I want to mine. 392.
392. Yes, we're there.
So let's then put it on the side. So you can see from the Falam report that the chapter deals with, it said the report submitted to the President and the media statement.
Yes.
Then let's look at first F4 at page 140. We don't have to really spend a lot of time in dealing with each of the F4 paragraphs, but let's turn to the ones that Falam found to be offending paragraphs. And that is page 141.
141.
141. And that will be paragraph 4 and paragraph 5, because we're going to have in the same paragraphs when we look at F5. Paragraph 4 then says, when the police started deploying the barbed wire fencing, a militant group from the protesters, armed with weapons, pangas, spears, axes, and firearms, hastily flanked the vehicles deploying the wire. They were met by members from the police who tried to repost the advance with stun grenades. The attempt was unsuccessful, and the police members had to employ force to protect themselves from the charging group. This resulted in the death of 16 protesters with 13 wounded at the scene. Then paragraph 5 says, the dispatching action had commenced at this time, and the protesters were driven from their stronghold to a high bushy ground in the close vicinity. The police members encircled the area and attempted to force the protesters out by means of water cannons, rubber bullets, and stun grenades. The police advanced to arrest the armed protesters, resulting in police officers having to again employ force to defend themselves at close quarters. This resulted in 13 more protesters' deaths, with 15 more wounded at the second incident. Then you can just read the remaining part as well and say, more people were reported to have died after being taken to the mine hospital. The total death toll of the protesters currently stands at 29, with more than 71 critically injured and others being treated for minor wounds. A total of 6 firearms were retrieved at the confrontation scenes, as well as numerous dangerous weapons, including pangas, axes, and spears. One of the firearms is confirmed to belong to the police official killed by the group on Monday. The SABC has secured the immediate area, although sporadic incidents of unrest have been reported after the incident in the nearby area. The number of dead and wounded may increase as the police comb the area for more wounded. So now, with this in mind, then let's go to page 137, which is the actual media statement. Now, I've said to the members of the board that when the National Commissioner had interaction with Judge Falam during day 105, she actually then owned the statement to say that is my statement. And I'm not running away from it. And that you will see that this statement, when it was delivered as an address to the media, it indeed uses the first language, then the first person, that is 137. It says, allow me to take you through the events as they unfold. So she's actually then speaking as a National Commissioner. So she's not speaking in generic terms. Then if you turn to page 138, where now we deal with the offending paragraphs which Falam found to have been offending, you'll see that in the media statements, those paragraphs then will appear as paragraphs 7 and paragraphs 8.
Yes.
Then let's now then read then the first one, 7. It says, when the police started deploying the barbed wire fencing, a group of protesters armed with dangerous weapons and firearms hastily flanked the vehicles deploying the wire. They were met by members from the police who tried to repost the advance with water cannons, tear gas, as well as stun grenades. The attempt was unsuccessful, and the police members had to employ force to protect themselves from the charging group. Then paragraph 8 then says, the dispersion action had commenced at this time and the armed protesters were driven from their stronghold to a high bushy ground in the close vicinity. The police members encircled the area and attempted to force the protesters out by means of water cannons, rubber bullets, and stun grenades. The militant group stormed towards the police, firing shots and wielding dangerous weapons. Police retreated systematically and were forced to utilize maximum force to defend themselves. And then paragraph 9, it tells us about the total death. It said the total death toll of the protesters currently stands at 34, with more than 78 injured, 259 people have been arrested for various charges ranging from public violence, murder, and attempted murder, malicious property, and so on. Now let's stop there and go to the report at chapter 16, at chapter 15. So at page 392, that is where Falam refers to F4 and then F5. And then when you turn to 393, he then he quotes F4 at paragraph 6. And then specifically quoting paragraph 4, which I read at page 141. And then also paragraph 5, which I also read there, which proceed to page 394. Then then he continues to quote the other paragraphs which I've read, then like the total number of the death toll and so on. But let's look at his analysis at paragraph 7 at page 394. Then the report says, it is thus clear that when this report was prepared, the compilers knew, and we know who the compilers are, I mean, even according to the evidence of Mashihu, and as well as the statement of Mashihu of 8 August 2013, the statement of Adrio of, I think it's March 2014, and as well as his evidence here that it is him and then Adrio. So he said that the compilers knew, and we're not concerned with the compilers because compilers' duty is to compile. By the end of the day, then you own the statement when you read it out. So to us, then it is of no consequence. So, but then just Classen that says that the compilers knew that there had been 2 separate shooting incidents at different places, which came to be known subsequently as scene 1 and scene 2. And let me pause here to say that Falam is correct here. Because if you read F4, indeed, then there were 2 scenes. And it's true that when F5 was drafted, they knew that, that it was 2 scenes. So that is clear. Then let's look at what it says in paragraph 8 then. F5, the media statement prepared later, does not disclose this. So now that is what we must now interrogate now as this board. Whether then this is correct or not. Because it says, it creates the impression that there was only one shooting incident which culminated in the police having to defend themselves with maximum force against a storming group of strikers who fired shots and wielded dangerous weapons. And then from there, then he quotes the relevant parts of the statement, which we have already referred to. And then that's now at paragraph 9 at the top of page 395. That's where he quotes then those paragraphs. Because in the statement, in the media statement, there appears paragraph 7 and 8.
Doesn't matter.
And then from there, then the paragraph page 396, he concludes now then to deal with that issue. Then he says, the statement in F4 that 13 strikers had been killed before the dispersion action started was excised, as was that separate death and injury toll at scene 2. Indeed, when you look at that statement, that paragraph which tells us about the number, that line which tells us about the number, they don't find it in the media statement. There is, in addition, an allegation that at the end of the engagement, the police had to deal with the militant group which stormed at them, firing shots and wielding dangerous weapons, was added to the statement. And of course, then we look at the statement and you'll see that that is there. In paragraph 11, it says, the effect of these changes in the statement issued to the public was materially misleading because it created the impression that there had been only one shooting incident which led to the death of the strikers. The public who had seen on television the shooting at scene 1 would inevitably have concluded that all the death had occurred while the police were defending themselves against the militant group which stormed towards the police. The changes were clearly not accidental because, as has been said, the wording of the relevant parts of the statement was otherwise visually identical. Then the National Commissioner, when asked to explain the difference, was unable to do so except to say that it was important for us not to be putting in detail that may not have been fully confirmed. But that answer is not a valid explanation of the changes. In fact, she considered that it was fair to say that she could not explain the reason for the changes. She added, however, that she was the owner and reader of the statement. So that's what I was talking about. Then he finally says, the Commission agrees with the evidence leader's submission that the most reasonable conclusion, so it is the most reasonable conclusion, is that the report which had been prepared for the President and the Minister was deliberately amended when it was reformulated into a media statement in order to obscure the fact that there had been 2 shooting incidents separate in time and space. This resulted in a deliberate misleading of the public, who were brought under the impression that all of the death had been caused at the confrontation as scene 1, which they had seen on television. Now let us pause here for let's pause here for a moment. Was there evidence before Falam as to what is it that the statement wanted to convey? You'll find no evidence to that effect. What you're left with is speculation here as it remains. Now that called for some evidence from the evidence leaders to demonstrate that the intention was, or first, what ought to be communicated to the public is the following. But what we know is that the report to the President was a report to the President in order to appraise him of what had happened. And it informs the President, as at the time when the statement was issued, precisely how many people died in scene 1 and how many people died in scene 2. But what is important is the last part of FFF4 at page 141, that's paragraph 10. The number of dead and wounded may increase as the police comb the area for more wounded. We now know that it is common cause that FFF5, which is the media statement, was prepared later, and that the number of deaths had increased because of those who had been in hospital, those who had been taken to hospital, some have been taken to the mine hospital. Now the numbers have increased, and now you communicate the correct situation as it appears at that time. When I asked Mr. Mashego about the last line in paragraph 4 and 5 were communicating, he confirmed that they were communicating the number of deaths, not the scenes. Because then the mistake that has been made here is to believe that the last line, which says this resulted in the death of 16 protesters and 13 wounded in that scene, that it conveys scene 1. And that the last line in paragraph 5, which says this resulted in 13 more protesters' death with 15 more wounded at the second scene, that it communicates scene 2. That is a misnomer. Because these 2 lines in these 2 separate paragraphs are communicating the number of deaths in those scenes. But the scene, you get it before you read that line. You get it from when you read the dispersion action had commenced up to before the line which starts with this resulted in. That is a scene on its own. Then when you come to the next paragraph, the dispersion action had commenced at this time, and the protesters were driving from their stronghold to a bushy area or a bushy ground. It's another scene. So this is what is communicated by the scenes. When you turn to page 138, which is now the media statement, paragraphs 7 and 8 communicate precisely the two scenes. But the only thing it doesn't tell you about is how many died in scene 1, how many died in scene 2. But it can never be suggested that paragraph 7 does not depict a scene. In fact, Mr. Masho confirmed that as well, that was also his understanding. And that paragraph 8 depicts another scene because it tells you about now a bushy ground. They're no longer in the stronghold where they were. So they're no longer in the copy because we know that later on that all these areas were given names now, so that everybody can communicate. But at the time when the police were communicating, they could not have then said that this is scene 1 or this is scene 2. They could have actually said that this is Roman figure 1 or Roman figure 2, or it is just A or B. But all what you have to know is that do the statement depict two separate incidents or areas or scenes? So it does. Then where Falam criticizes the statement, members of the board, is that because the media statement does not communicate the number of deaths in each of the scenes, then it is misleading. But it can be in the light of paragraph 10 at page 141, which says that the number of the dead or wounded may increase. Now we know that the numbers indeed increase because that number now is communicated in paragraph 9 at page 138, that the number is now 34, it's no longer 29. But what you will not know at that stage is how many of the 5, when the report to the president is prepared, the number is 29, and you are able to identify them because you are able to add 16 and 13. Then you come to 29. And because of them, these are the people that you were able to precisely identify as to how many died in this scene and how many died in the other scene. Then you can allocate the numbers then to the different scenes. But once the numbers then increase, you have 5 more who are dead, and you're not able to allocate them to a specific scene. You will then be misleading the public if you were to actually then allocate them to one or the other scene, especially taking into account that there's still a civil liability that may come, and you find that you have actually then miscommunicated material information. So I will submit, on a rational basis, a prudent national commissioner will ensure that she does not communicate to the public wrong information about how many people died, and secondly, where they have died. And that's precisely what she did here. So we see nothing when we interpret the media statement which could have been interpreted to be misleading the public that the death occurred in one scene. Chairperson, you remember when Mr. Mashiu was testifying, you even picked up yourself that when you look at the numbers of the injured, the numbers themselves don't tally. And that actually appears in FFF4, the very same document that we are told that it is accurate. It just tells you that when the police were working in these difficult circumstances, it is completely unreasonable to come now during the peacetime to want to judge them in the same environment of peace. It can't be. It is the same as you try to judge the mental state of a soldier during the time of war, in the middle of war. And you want to judge his thinking and his taking of decisions the same way during the time of peace. So all those were not taken into account when the National Commissioner was criticized by saying that the intention was to mislead the public. So that's what we're saying, and we're not saying anything more. We're just saying to you that if you find that they communicated the wrong numbers to the public, that is misleading. If you say that the president was told that 29 died, and now the public is told that 20 died, then you are misleading because you want to portray to the public that few people died instead of more. Because you have more problems when you can communicate to the nation that more people are dead. But you have this national commissioner who was prepared to face the nation and say that we have 34 people who are dead. But does it matter as to they've died in scene 1 or scene 2? It doesn't matter. For the public, all what they know is that people are dead. And that's why then people are being communicated. So we submit that on the interpretation of the statement itself, this board should find that The media statement discloses 2 sins, and the media statement communicates the correct number of the people who are dead. And if you find in our favor on those 2, there is no reason then to go further and interrogate as to why then this and that was said, because then the statement was read by her. So that's all what I'm saying. But let's look at Mr. Mashihu. It is so incredible that Mr. Mashihu was a witness who was called here to testify and who deposed an affidavit on the 8th of August 2013. After the National Commissioner had testified, the National Commissioner testified on the 3rd of June 2013. He says he watched her then testifying. Then he deposes to an affidavit on the 3rd of August 2013, 2 months later. And he does not mention this allegation that is coming with for the first time, that she has made certain changes which are material. And that is quite significant, especially when you look at his statement of 8 August, because his statement of 8 August is very specific, that he actually is the one who participated in the preparation of F4. And nowhere does he say that the National Commissioner dictated changes. Mr. Mashihu was a media officer. What is the duty of a media officer? Is to draft statements for the National Commissioner. So imagine having a media officer who turn and now say that, I've drafted the statement, but this part was dictated. Extricate himself from that because he knows that he drafted the statement. Then the reason that he gives this board, he says that, no, I came forward because she implicated me in F4. But why would you have any problem with F4, which then Judge Faram has found that it is accurate, is a perfect statement, and that F5 was supposed to mirror F4. So, especially that, given the fact that when Chairperson, you engaged him in order to ascertain whether then we can accept his reason to be a bona fide reason why he did not mention the changes in his first statement. He was going along with you, then, the Chairperson, to say that, look, at that time, then, the National Commission had not yet testified, so he didn't know that, he has thought that, that she was going to implicate and so. So he went along with that because then it was a version that he liked. Until when he was shown that, in fact, the National Commissioner by that time had already testified. So this is a witness who just came here to give an untruth, a blatant lie then to this board. So then the evidence of Mashiu must be completely rejected. In fact, if then this board were to scrutinize the evidence of Mashiu and his statement of the 3rd of May and read it together with the statement of Adrio, you'll think that these people were not, they were not together. You'll find Adrio's statement in Bundle B. And both of them, the evidence leaders are relying on both statements, mutually destructive as they are. The first statement of Adrio, you'll find it at page 7 of Exhibit B. Now, it's a bit of a long statement because it goes up to page 12. It does not have a date, but he signed it in March 2014. Now you can see that Adrio actually signs it even much later, almost 6 months after the National Commissioner had testified. And nowhere in this statement does Adrio talk about it and the National Commissioner making any changes. Then Adrio is approached by the evidence leaders again for purposes of this inquiry to give another statement. You'll find it at page 13 of Annex B, then Exhibit B. It's a very short statement of his. But when you turn to page 14, paragraph 4, then he says that, paragraph 4, he says, with regard to the statement by General Phiyega in evidence that Brigadier Mashiu and I prepared the internal briefing document, Exhibit F4, and that we did so on the evening of 16 to the early hours of 17 August 2012, I state the following. I have no recall of having prepared this document. But when you go to the evidence of Mashihu then says that, that document was prepared, that Adrio was then part of it, because Adrio has always been based in Americana, but with the help of the commanders. And also, but I'll come to this. Let me just finish first with the statement, because we are now then, at Adrio's statement. So then Adrio does not have a recall. And then paragraph 4.3 says, I spoke to Brigadier Mashiu telephonically on the evening of 16 August 2012, and to the best of my recollection, we discussed the preparation of a brief media statement and invitation to the media to attend a press briefing by the National Commissioner on the following day, 17 August 2012. To the best of my knowledge, the document that was prepared by Brigadier Mashiu is a media statement and invitation that appears at Annexure B to his aforementioned statement, and was distributed that same evening, 16 August 2012. Having regard to the wording and the context, says that he can't, then that's not how media statements are drafted. But then it says in paragraph 5, with regard to Exhibit 555, being the media statement issued on 17 August 2012, I state the following. This document was prepared by Brigadier Mashihu and me on the morning of Friday, 17 August 2012. As I recall, when I arrived at Marikana, Brigadier Mashihu was already there. In preparing Exhibit 555, he worked, and that's very important, he worked off a template of another document, which to the best of my knowledge was Exhibit 554. Now we know that Mr. Mashihu came 2.5 years later on the 3rd of May with some affidavit where now then he's telling a completely new version altogether, that in fact he got a memory stick from Adrio, and that stick was given to Adrio by Scott. But then Adrio actually found him there already. So these are mutually destructive statements, completely then different. And then, but importantly, let's look at 5.4, what then Adrio says. He says, before that document was finalized and approved, and it's referring to now then to then the media statement 555, I left in order to organize the venue for the media conference set to take place later that morning. What does Mashiu say then to this board? He says, no, then I was there with Adrio when the National Commissioner was dictating to me. But then Adrio then left. That's why Adrio in paragraph 5.5 says, although I was not present, it was the invariable practice in our unit that media statements, especially one of such importance, would have been given final approval by the National Commissioner himself. I believe that Brigadier Mashiu will have taken the document as prepared by us to have for her approval prior to it being released to the media. So you can see that Adrio says that I don't even know that Mashiu gave it to the National Commissioner. But then the very same Mashiu says that Adrio and me were there when the National Commissioner was dictating then the document to us. And that's why in paragraph 6.1 at page 16 it says, I was unaware of the existence of a second incident or scene at all until the morning of Friday, 17 August 2012. Adrio says I was unaware that there was scene 1 and scene 2, or there were 2 scenes. And members of the board, I'll tell you why that he's saying so, and he's correct. Let's look at Annexure B. That is the statement, because remember that the first person to communicate to the media one scene was Mashiu. And he agrees with that. If you look at then his annexure to his statement at page 159. 159.
159.
No, 129. So 129 is Mashiu's statement of 8 August 2013. In that statement, you'll see, Chair, at paragraph 4, he says the following are media actions which I was involved. And when you turn to page 130, he refers to Annexure B there. He says a media statement which also served as an invite was sent on the 16th August 2012. I was involved in the formatting, compilation, and distribution of it to the media. So that's the statement that then he's talking about. And when you look at that Annexure B, which is referring to, you'll find it at page 135. And that is a statement that he admitted in evidence that he sent it to the media. And this is a statement that is completely extraordinary because it is a statement which unmistakably informs the media about one thing, and he considered that. So you'll understand when Adrio said that, until the morning of the 17th, myself, I didn't know that there were two sins. I didn't know that there were two sins. This is quite telling the members of the board, especially in the light of the fact that Adrio says that, insofar as how the statement was finalized, I don't know. But he says that I, together with Mashiko, prepared the statement. But its finalization, I was not there. But let's look at the importance of this in the light of the evidence that we now know that 135 was a media statement which was communicated to the media by Mashiko. When they were preparing the statement, then he knows about only one thing. But when the statement comes out to be read out, I've shown them to the members that when they look at paragraph 7 and 8, then they clearly communicate then two different things. So on what basis then will Mr. Mashiko then want to say that the person who actually conveyed for the first time or wanted the media to believe that there is only one sin is the National Commissioner, when it is actually him who told the media that there was only one sin? But what is extraordinary than members of the board is, whereas paragraphs 7 and 8 of the media statement unmistakably then demonstrate two things, what does he do himself? He imports at the end the paragraph which appears at page 136. If you look at the paragraph at 136, so this is the paragraph which appears in his own statement. No, it's the one at page 135, the second paragraph. You see the second paragraph, we start with, this resulted in several individuals. This resulted in several individuals being fatally wounded and others injured. The crime scene, which covers a vast area, is currently being managed by senior officials from the Independent Police Investigation Directorate and supported by an expert team of detectives and forensic experts. Now let's go to that media statement at page 137, but in particular to the last page of it, which is 139. Paragraph 12, do you see that? The crime scene, which covers a vast area, is currently being managed by senior officials from the Independent Police Investigation Directorate and supported by an expert team of detectives and forensic experts. So despite that, paragraph 7 and 8 at page 138 then seek to depict two things. He still takes his own paragraph then from his old statement, which talks about one thing, then he imports it into the statement. Then he wants to come here and attribute that to the National Commissioner. So the evidence of Mashiko, it was so hopelessly inaccurate, but we know the motive why he came here. He didn't come here to assist this board, he came here to clear his own name.
Yeah. You need to finish now, Mr.
Yes, indeed. Yes, indeed. In fact, then my learned colleague here shows me a transcript where Colonel Scott was cross-examined by Advocate Classen, and that's day 133. So I'm working from the hard copy. I know that the chairperson is working from the electronic one, so but it's day 133, page 14081.
14081.
Yes.
Line?
Line 7, where Advocate Classen, one of the evidence leaders, said to Scott, Colonel Scott, and you state, I received input from many sources. So they're talking about now the triple F4, the internal memo, because then the internal memo was drafted by with the inputs of commanders, and of which Scott was one of the commanders. So he then says, I received input from many sources, including Brigadier Pretorius, with regard to the history and statistics to the violence and from Captain Adrio, who was monitoring the video footage, then from the photographs handed in by Lieutenant Colonel Vermaak. So he was part of it, then we know that, Adrio was part of it. But then there is this accusation which you must then get out of the way as the reason why Mashul says that he came here, that in fact then he was implicated.
Well, you've dealt with that already.
Oh, okay, thank you very much, yes.
I think if you want to conclude, you must now go on to terms of reference number 5.
Yes.
Sorry, Judge, could I just get an indication of how much longer we're going to sit for? Because it's clear to me now that I won't be able to present my reply.
Yes. Oh,
What time is it now?
It's 5 to 2 already.
No, term reference 5, I'm going to be very brief, probably then between 10 and 15 minutes.
Well, then I think you should do that now.
We should do,
Will
okay.
that be the end of your submission?
That will be the end of our
All right,
submissions.
let's do that.
Okay, thank you. Now let's come to the last term. The last term, as we know, is the overall testimony of the National Commissioner at the Falam Commission of Inquiry. And I'd like to say that we agree with the manner in which we say that the chair, Chair, you understand the scope of this term, that it relates to the evidence, her evidence at the Falam Commission of Inquiry. So we know that the evidence leaders have identified various topics under which then they want to impute that her evidence was inappropriate and therefore renders her guilty and she is not fit for office. But then let's look at their statement of case, because we can deal with this in relation to their own statement of case. Somewhere. Okay, I've got it here. Now, this term of reference starts at page 98.
Page
998
98.
Of the evidence leaders. Let me see.
Statement.
No, it's 92. 92.
Yeah.
92. Let's look at what they're saying here. Well, first, they deal with the legal framework within the national, and they extensively quote from the interim constitution, which has been repealed. So let's forget about that.
You don't have to repeat that.
We don't have to repeat that. We know that it's been repealed. There was no need for them to even refer to it. Then let's go to page 102. Then 102, they say, was the National Commissioner's testimony in keeping with the office. Then they simply tell us how they understand this term of reference, and they're making nothing out of it, except that at page 103, they tabulate the topics that they say that must be considered in order to determine the overall evidence. That's page paragraph 162, and they identify about 8 topics. And then at 104, they deal with each of those topics, starting with the National Commissioner's misunderstanding, misstatement of a constitutional and statutory function and responsibilities. My learned colleague here, then Ms. Sello, has dealt with how the legal framework works. I've dealt with how the legal framework works here, and it is clear that she understands her constitutional powers perfectly well, and that the evidence leaders have got it completely wrong. So if you turn to page 107, then they say the making of public statements by the National Commissioner without her having the relevant facts. We know that there is no testimony to that effect, and this is what then is an imputation whatsoever. On the statement of the parade of the 20th, So a reference to the 17th, of course, it must be the 20th at paragraph 171. And then also then they're referring to the
rover incident.
well, that one, then it has been expunged, then we can forget about it. And then we go to Fermark. Then Fermark, we know that it is in relation to the incident where they say that Fermark said that he had certain information, he met with the National Commissioner, and the National Commissioner commended him for his courage. And they said, based on that, then, the National Commissioner then, there must be an imputation because on the National Commissioner that she did something which they don't tell us what it is, because they say that Fermark ultimately did not testify under the banner of the legal team of the SABS, but he testified under the banner of the evidence leaders. It baffles the mind as to on what basis then it's been alleged that now the National Commissioner comes in there, when they say themselves that the National Commissioner commended him for that. So then we see nothing really changing. So then turning on this, and then we have now then page 118 is the National Commissioner's General Testimony, the Falam Commission, and they're referring us to the exchange at 194 between the chairperson, that is Judge Falam, and the National Commissioner. But we fail to understand on what basis then is it said that this exchange then makes her then not to be fit. Then when you look at the bottom of page 119, the National Commissioner's misleading statements in the representations to the President, we know that then what they're relying on in this regard is to say that she refers to the SAPS training manual, which they say then doesn't exist. Actually, then, members of the board, you must have seen that both in our statement of response and our heads, we have expressed such an extraordinary puzzle that how can then the evidence leaders who are supposed to have access to all the SAPS manuals do not even know about the existence of this document, but it was ultimately given to them, and we've even attached it to our heads of arguments. But what is quite extraordinary, then, members of the board, to show that we can't have a situation where then when there is a serious matter of this nature, where the National Commissioner is accused of serious allegations, then we have the clutching of straws, taking even some small things which have no significance whatsoever. When the National Commissioner, in her own representation to the President, she extensively quoted from that document. So how can she quote from the document which does not exist? So then nothing really turns on that. And then now the last one is the National Commissioner's unwarranted attacks on the Falam Commission. Again, we say this is a clear clutching of straws. How do you even come to that in a constitutional democracy, where people have the right in terms of Section 33 of the Constitution to actually then, attack then the findings that are made, as long as they can do so within the confines of the law. And she did not utter this to some street person there. She didn't stand on a pedestal and shout to the world and say that. She wrote to her boss, then to her superior, the President. Then they get the submissions from the President. Then they want to use that, then against her in this inquiry. So we find that completely uncalled for. So what really then remains, members of the board, is what is the appropriate finding that you must make. So we now then go to the legislative scheme, which is now Section 8, which now then tells you So the Section 8
Of the SAPS Act.
Yes. I just want to refer to it because then it sets out then your powers. Obviously, if you find that she's not guilty of any of these charges, then you have to acquit her. If you find that she's guilty of one or two, then you're going to interrogate whether those charges warrant declaring her unfit for office. But then let me clarify this, members of the board, because it's quite important, especially in the light of the fact that we're dealing with a disparate hearing here. We must not really be carried away by terminology. Where Section 8 refers to, and Section 9 to things like unfit for office, Section 8 refers to removal. all what it talks about is the dismissal. So it's a dismissal. So it means that if you find that the charges are serious, well, it means first you must find her guilty. If you find that the charges are serious, she must be removed. And that removal means it's dismissal. So basically is that if you find her guilty, you go to the next step. The next step is what? It's an appropriate sanction. The only thing that we see that there's no distinction in Section 8 right to Section 9 of the SABC, as you'll find in the Disciplinary Code of the Public Service, is that you don't have to first find a guilty and convene us again for us to determine the appropriate sanction. Because you are simply going to make recommendations to the President. The President is the one who will take a decision. Yes. But it's just a dismissal that didn't contemplate. But the dismissal can only come if you find that these charges that you have found guilty of render her unfit for office. If you find that they do not, then you have quite a number of options which are set out in Section 8(6). So you can say that no action be taken against her, or you can recommend things such as a reduction of her salary, or that she be transferred to another department. So you've got a whole lot of options. And those options remain within your discretion. And we are confident that you'll be able then to do that in the event that you find that, she has done wrong in one or two of them. But we are saying that, firstly, based on the evidence that we've presented, you should actually acquit her of all the charges. Yeah. So then those are our submissions, and you will see that in our heads of arguments we have concluded as such. Then at page 81 to page 84, and where we conclude by saying that for all the above reasons, the National Commissioner should be acquitted of all the charges. Just a moment. Okay, my learned colleague just said that I should refer members of the board to our heads of arguments, page 64 of our heads of arguments, page 64, paragraphs 164 to 172 at page 67. Where we're dealing with Exhibit L. Remember that there was a debate about whether Exhibit L constituted evidence or whether then it was just a presentation which then was made at the Falun Commission. So we are setting out then the circumstances under which Exhibit L got introduced, and you will see that at page 65 of our heads, paragraph 166, we have quoted at length the interaction between the chairperson, Judge Falam, and Advocate Semenya, who was the lead counsel of the police, about the status of Exhibit L. So it is clear, even from the record then at Falam, that Exhibit L was never intended to be evidence on its own. So like then, members of the board then to just take that into account, the paragraphs that I've referred you to. Finally, members of the board, I think it came from the submissions by Mr. Nsebeza about the families then waiting for answers and so on, and that there was no apology from the National Commissioner. So members of the board will find that interaction at day 64. Day 64. Pages. So it's day 64, page 6795. 6795 lines 21 to 25, and then you get it also at page 6796 lines 1 to 6.
All right.
So the apology was made, but in the context in which the not apology of wrongdoing, but apology that there is a difference between law and morality, and we know that we separate the two. So it is an apology on the basis of morality that you have 34 people who have died, plus 10 is a total of 44 people in a space of 9 days who have died in one place. So that apology was in that context, and it should be understood in that context.
Thank you.
The further references that I'm given to under the same date is page 6849. 6849, and that's paragraphs, lines 12 to 20. And then the other page is 6850, lines 14 to 20. And in all instances, then it was the National Commissioner testifying, and then at 6849, it was actually the National Commissioner with interaction with Advocate Nsebeza, and also then the chairperson coming in there and there.
Yeah.
So this, members of the board, will conclude our submissions, and we hope that we have submitted comprehensive heads of arguments, which at your leisure then you'll consider together with the record which is before you. And thank you very much for your time.
Can we ask you one question regarding when you want to submit any further heads of argument in regard to the submissions made by Mr. Mpofu and Mr. Nsebenza?
Okay, my learned colleague informs me that we should be able to do that by next week, Friday, but I may qualify it. The submissions, if we do, will only be limited to the submissions made by Mr. Nsebeza, not to Mr. Mpofu.
Only Mr. Nsebeza.
Then only Mr. Nsebeza. Then insofar as Mr. Mpofu is concerned, my learned colleague has dealt with his submissions when she dealt with it yesterday. And then we'll deal with maybe then the submissions that were made by Mr. Nsebeza. But overall, our approach then to the two intervening parties, members of the board, is that they've added nothing to this board for this board to be able to make its determination. So the board is going to make a determination based on what was submitted by the National Commissioner and the evidence leaders. Nothing which was submitted by these two intervening parties turns on the terms of reference, as we have said. You have seen that the evidence leaders have defined the scope of their case in the statement of case, and we actually responded to it accordingly. We filed heads informed by that, and we don't see anything which was added by these two intervening parties to that effect. But we're leaving it there, and that is suffice, we can take it.
All right. So that will be by Friday, the 10th of June.
The 10th of June, indeed.
And you will submit it to all.
We'll submit it to
email
all,
and
yes.
hard copy to the Secretary.
Thank you very much, Chairperson.
Yes.
Judge, if I may.
Yes, Mr. Jammeh.
We were all hopeful, and I don't impute any blame for this, that the Commissioner's submissions would have been completed by lunch, in which event I intended to address you in reply. That's not happened, and unfortunately, we've run out of time. So I propose, Judge, that we submit a written reply to the argument.
Yeah.
Much of the argument is not contained in the heads of argument, so with respect, I believe we'd be entitled to do so.
Yeah.
there's new material, new regulations, etc., put before us. We need to consider them. But I would like to just respond, if I may, to two aspects before we adjourn. The first is a statement by my friend, Mr. Mokari, to the effect that the manual that is referred to in the response by the National Commission to the President was furnished to us. That is not correct. It's not been given to us. Till now, we've not seen it. And as we say in our statement of claim, we'd asked for it from the National Commissioner's attorney. It has not to date been given to us. That's the first point. The second point, Judge, is there was, quite an attack on Mr. Masheke, our witness. And I just want to place it on record that much of that attack was based on assertions that were not put to him in cross-examination. And we will deal with that in our response. In fairness to Mr. Masheke, I want to put that on record. Thank you, Judge.
Well, before you leave, when are you going to submit your written reply?
I would have said next week, Judge, but there's quite a massive material that I think we need to address, so I prefer the following week.
So, but we must have an indication.
I should be able to do it by Wednesday.
Wednesday next week?
Not next week, the week after.
Wednesday, that will be
10th, 11th, 12th, 13th, 15th, I think, Judge.
15th.
Yes.
15th of June. The next day is a public holiday, so let's do it on that day. All right. So you will then respond in writing. Now, I can see you, Mr. Mpofu.
Judge, before Mr. Mpofu comes in, I'd like to respond to the Mr. James' request. From where we stand ourselves, we have no objection to his request, so he can do that, and as long as he circulates the reply to all the parties. Insofar as the manual that he's talking about, I must understand that we have attached it to the heads. If you didn't get it, then we can send it to you again. It's fine. And actually, then my attorneys informed me that it was even sent even earlier. But if you didn't get it again, we'll send it again. It's not a problem. Or we can give you a hard copy. So, but we are not opposing their request.
Yes, thank you. Are you happy with the manual being sent to you now, Mr.
I would just like to see the manual. It's never been given to us, Judge.
All right, fine. So it'll be sent by your attorneys.
Indeed.
And sorry, Judge, to the extent that there's going to be engagement with Mr. Mpofu now, could I be excused, please?
Yes, you may be excused.
Thank you very much. And I do associate myself with Mr. Mokari's thanks for the time given to us by the board. Thank you very much.
Pleasure is ours. Mr. Mpofu.
Yes, thank you, Judge.
Quick.
Very quick.
Quick.
Yes. 5 minutes. Judge, just in the interest of time and to avoid having to do anything written, can I just make 3 quick remarks? The first one is regarding to what my learned friend Ms. Silo said yesterday, that about whether this is a disciplinary process or something akin to it and so on. I was saying our only submission was that it's not merely a disciplinary action, but obviously it is a disciplinary process, but it's more than that. It's also about the fitness of office. That's the first thing. The second one is that she says that you have to interpret, in relation to our submissions, you have to interpret the terms of reference within the 4 corners of the document in front of you. And we agree with that, but what we're saying is that obviously the board has a duty to interpret the document in front of you. And in doing so, the material which is on page 1 of the terms of reference is important, where it says whereas this and that, the 1, 2, 3, 4 whereases. Because the part that they want to confine to comes when it says now therefore, and then it gives the terms of reference. No document can start with the words now therefore. It must take into account what is said before the therefore, which connects it thereto. And therefore, but the only submission we really want to make now in relation to term of reference.
Is that your third submission?
Yes, with term of reference number 5. I'll summarize as this, Judge. Where it says the overall testimony by the National Commissioner at the Commission, it starts with the word whether the overall testimony by the National Commissioner at the Commission was in keeping with the office which she holds and the discharge of her duties commensurate therewith. We'll ask a rhetorical question, whether those duties that are listed there, do they or do they not include Section 25 of the Police Act and Section 199(6) of the Constitution and Section 199(7) of the Constitution.
Okay. All right.
Oh, I'm sorry, Judge. The last point is on page 443 in relation, you remember there was the so-called leadership point, who's included in the leadership and so on. If you go to page 443 of the Falam report, you'll find that no less than the National Commissioner herself said the following. It says, when asked what specific support the minister gave before the shootings on 16th August, she said, quote, "He is our political leader. He took us, he gave us political support. He gave us that leadership because I do not have the responsibility of communicating in that space," and so on. And there are other quotations. In other words, she recognized him as part of the leadership, albeit the political leadership. Obviously, she's the leader of the operational leadership. But the terms of reference don't give adjectives. They simply say the leadership. So it must include both the operational and political leadership. Those are our, thank you very much, Judge. I also associate myself with the colleagues, and I'm sure I speak for Ms. Mutluanya and Mr. Ntsebeza, to thank the board for having allowed the victims some voice in this process. Thank you very much.
Well, it is now almost 2:25. This will then conclude the hearing, the public hearing.
Sorry, Judge. Sorry. Before you adjourn,
Yes.
on behalf of the families, I'd just like clarity because there was a discussion in chambers with our colleagues yesterday. The defense team has been given the opportunity to then file supplementary heads in relation to those aspects which were raised by the families team. Just to get clarity and an indication whether the families team
carry something. Shh.
Yes, Ms. Silva?
Thank you, Chair. I just wanted to probably assure or explain to Ms. Mutlwenya what request we had made. And it is not so much, and because if I recall, she was not present when this issue first arose. It was the other junior. Our request had been, due to the late admission of the families, they had missed the opportunity when evidence was being tendered, because then we were met with specific evidence and we countered with evidence. Now, what they have in their heads of argument is a combination of both evidence and argument. And we had requested an opportunity just to deal with the evidence aspects, to afford us the opportunity that we had when the evidence leaders confronted us with evidence to go find countervailing evidence. So our heads of argument will go no further than that. It really is about the evidence. Any positions that they hold in their heads of argument, any legal argument they make will stand and we will not reply to it. Yeah. So it is on a very limited basis. Yeah.
Are you satisfied with that?
Then I do understand.
And as far as Mr. Mpofu is concerned, there's no necessity for you to reply because they've said they're not going to reply to you.
Well, they replied yesterday. They said they replied yesterday.
Yeah.
No, we're quite satisfied, Chair. And we ignore the unsavory remarks at the end. We hope that the National Commissioner herself is appreciative of the healing effect to the victims of participating in processes like this. But, you know, that's, if not, that's not our problem. But,
well, this then concludes the public hearing of the Board of Inquiry as set up by the President. We will now adjourn, and then we will then await further submissions in writing, and we will then consider our views, and we will then draft a report which will be made available to everybody as provided for in the Act. And I want to thank all of you for the hard work that the legal teams have put in. You have prepared substantial heads of argument. The statement of claim, the defense was also substantial and assisted us greatly in coming to grips with the evidence that was led before the Farnham Commission, which, as you know, is a substantial document, and we want to express our thanks and gratitude to the legal teams for having assisted us in this regard. Thank you very much, and may you all have a blessed day. We will adjourn.